I see quite a few lawyers here. If you're not a lawyer or if you haven't brushed up on constitutional law, please take one of the, I think, thousands of copies of the Constitution that we have out on the front table. Very handy. And I always found, even as a law student, just leafing through the Constitution, the things that you will find that will amaze you as to how detailed it is, as to how the country is structured and how it runs. But the Fourth Amendment, as you'll probably recall, deals with searches and seizure. Seizure being when the government in some way stops or holds on to a person or property or something like that. Search is hardly needing of explanation. But the case I'd like to tell you about is from the state Supreme Court, and it has the unpoetic title of In Re Appeal of Application for Search Warrant. And it is about a search warrant. For those of you who have never seen or haven't dealt with the criminal justice system, search warrants are, that's, if you've ever had a television, I'm sure you know, it's the process by which the executive branch, so the police or a prosecutorial agency, gets permission from the judicial branch to invade somebody's privacy. And what happens is the police or prosecutor goes in front of a judge and says, I have the following facts that I think establish what we call probable cause to believe that a crime has been committed or is about to be committed. And the judge then has the opportunity to say, yes, here's your warrant, or no, you don't have it, come back when you have more information. The interesting thing about search warrants is that they are what lawyers call ex parte. So unlike usual court proceedings, there's nobody on the other side of a search warrant dispute. There's nobody to argue for the privacy rights of the person whose property is going to be searched or who is going to be arrested or something like that. So in many cases, it's down to the judge to think about, well, is this warrant application overly invasive? Does it comport with the Constitution? And so some very interesting things come out of the judge's role in warrant proceedings. The search warrant case centers around an identity theft or an identity theft attempt that we think happened somewhere in Burlington. And what happened is an elderly man in upstate New York reported that someone had applied for a credit card in his name. And he didn't want any more credit cards, and he sure hadn't applied for one. And so it was probably a case of identity theft. And the New York State Police ended up tracing it back to somebody who they think committed the crime in Burlington. The Burlington City Police narrowed the list of suspects down and identified the house from which the computer transaction occurred. But there's more than one person living in the house. So the Burlington detective went to the Superior Court there in downtown Burlington, applied for a search warrant, and asked to seize and carry off of the property every computer in the house, regardless of who it belonged to. Every CD, DVD, flash drive, telephone, any electronic device that could be found in the house. The trial judge, kind of understandably, was concerned about the breadth of the search. The search warrant application recited things like, well, based upon the police officer's training and experience, any electronic device found in the house is likely to have been involved in the commission of the crime. Which I think if you live with any other person or if you have children, you realize that what one person does with their computer has almost nothing to do with what somebody else in the house does with their computer. And so the trial judge, kind of on his own, looked at this and said, well, look, yes, there is probable cause to believe that a crime was committed, and it's appropriate that a search occur, but not in the depth and with the breadth that you've proposed. So the trial judge imposed some conditions on the search and said, for instance, the first thing that's going to happen is the computers will be taken off site and they will be what's called imaged, so that they will be copied kind of byte for byte, and then you'll give the computers back to the suspect, right? Just as a functional matter, if you think about computers, if you were to lose use of your computer for like 6 months or a year, it's practically worthless when you get it back, right? It's so old. Or if you lose your iPhone or your cell phone, right? I mean, that can be a real impediment. So judge said, first of all, you're going to image them and give them back. Second of all, search has to be done by somebody other than the police or someone who's walled off from the police investigation. This is a very common technique in civil litigation in electronic discovery, but it's brand new for the criminal world. The judge imposed several other conditions, most of which boil down to the fact that the police could only look for evidence relating to the identity theft that was alleged. So what he said was, you can't go through this guy's entire digital life and find any evidence at all of any crime and charge him with that crime. You're only allowed to find evidence relating to the identity theft that you've come to me and said you've had probable cause to believe occurred. It turns out that there are only 2 or 3 other instances in the entire United States of a judge doing this, imposing the conditions on a digital search before it occurred. One was out in San Francisco with the news coverage 3 or 4 years ago of the Balco dispute, where the feds were onto this lab that is alleged to have provided Barry Bonds and other big home run hitters with performance-enhancing drugs, and the feds obtained a warrant to get some blood samples from a select number of major league players, and when they got to the lab, they took all of them. And so there was some litigation in California over the permissibility of that. But a trial judge here in little old Vermont picked up on that case and decided that he would impose the same conditions. Prosecutors took the warrant and seized the computers, but then petitioned to our state Supreme Court and asked them to review 2 things. One, whether a judge can say, when he's looking at a warrant application, yes, but. Right, we all know the judge can say yes, the judge can say no, but the question is, can the judge say yes, but? The prosecutors said no. They didn't think the judge was able to tailor the search to the invasiveness that was appropriate. And they also questioned the propriety of the conditions that were placed on the search. And because there was no party opposing the search warrant, it's an ex parte dispute, a couple of groups came in on the side of the absent defendant, one of which was the Vermont Defender General's Office. The other group was the ACLU of Vermont, the ACLU, our national headquarters, and the Electronic Freedom Foundation from San Francisco, which does a lot of work on civil rights and some other stuff in the civil world, copyright, trademark, things like that. And unsurprisingly, we argued that, A, the judge perfectly well has the discretion to limit the invasiveness of searches. And if you go back and look, there are a ton of cases with things like police wanting to do surgery on suspects to remove a bullet, and there's plenty of instances in which the judge says, whoa, that's a little much, right? That's a little much for this instance. And we also argued, unsurprisingly, that the conditions, tailoring the search in the way that the judge did is really appropriate for the digital world in which we live, right? Our entire lives are packed onto these little computing devices. I know that in our office, I've reduced 50 banker's boxes onto a little storage device that's the size of half a loaf of bread, in part because paper can get lost, stolen, or burn up, and if you store everything digitally, you can back it up elsewhere. But if the police seize a digital device, there's just so much information there that's part of our lives that it was really important for us, the ACLU, to say the judges have to be aware that this is the world we live in now, right? It's a rarity to find somebody my age or younger who has a good deal of, printed books or CDs or things like that, right? That's all digital now. So that the Supreme Court agreed with us in large part and said that, A, judges have the discretion to tailor the search to make sure it's not too invasive, which didn't really surprise any of us. But they agreed in large part that the conditions that the trial judge imposed in this case were appropriate for what was seized. So all of the computers, and I think there was an iPad that was taken. There was only one condition that was struck, and it's a little nerdy if any of you are real Fourth Amendment fans. There's a very interesting discussion about the plain view doctrine back and forth between the dissent and the majority in this case. And I commend it to you if you hadn't already read it. For us, though, this case goes beyond kind of digital searches and starts to really acknowledge that digital data is not just everywhere in our homes, but increasingly it's going to be everywhere in our lives, right? There are these systems of surveillance that are now coming online, and even here in Vermont, in which digital data about our everyday movements is aggregated in really large part. I think the first hint we saw of this in Vermont was what are called ALPRs, the automatic license plate readers. These are systems that are attached to police cruisers that scan license plates as they go by the cruiser, right? They can scan thousands an hour. I mean, they're computers. They work so much faster than we could. And currently we've come to learn that in Vermont, the state police store all this information about where and the precise location they saw the plate and when for, I think, 4 years is currently what's going on. So this concept of data retention is really big with the ACLU. This is something we're trying to get people to understand. This is happening now, and it's very important. The second way that I think you're going to see this issue come up in Vermont is with what the police call UAVs, unmanned aerial vehicles, aka drones. We're not aware of any Vermont police force having a drone at the moment, but we are aware that the Border Patrol has begun flying drones on our southern border with Mexico and has said that it will begin flying them on our northern border with Canada. So we are approaching a time when kind of persistent aerial surveillance of property in Vermont is no longer an expensive rarity, but is becoming much more possible and likely to be much more common. So we're very concerned that in the future, judges be able to recognize that the amount of information about us in our everyday lives is just gigantic, and that there have to be limits that the police are held to in order to keep some semblance of our freedom. So that's a very important case that I commend to your free time browsing, should you have any.